everyone, and welcome to Crime in Court. This is the Canton cover up Commonwealth versus Karen Reed, and also we talk about Turtleboy on this channel. That is Aiden Turtleboy Carney. He is the independent blogger, as they love to call him. He's a journalist, an award winning journalist, but they love to call him a blogger. And he has been I mean, the Commonwealth loves to call him a blogger, and they have charged him with witness intimidation. So today we are going to read Turtle Boy's motion to dismiss. And um, tomorrow, as you're watching this, tomorrow is going to be the hearing in the afternoon. Turtle Boy will be arguing the motion to dismiss. I don't know if it's going to be televised. I don't. I'm sure at some point we will get either audio or video of the hearing. Although I don't know if we're going to get it on the day of. But anyways, as you're watching this, this is the day prior to the hearing on this Odell motion. So this is the full. Oh, let me shrink myself so you guys can see. The full title of this motion that we're going to read is Aiden Carney's McCarthy/Odell motion to dismiss indictments for lack of probable cause and for the prosecutor's impairment of the integrity of the grand jury with misrepresentations of facts and law. And now this is just so you know, it is a redacted version, and um, there's going to be a lot of redactions in here, but we have what we have, and that's what we're going to go through. So I thought it would be great to go through this on the eve of Turtle Boy's hearing, kind of to remind us of what they've been doing to him and how corrupt they are. So let's get into it. Please hit that like button if you don't mind, and we're going to get started because this is a 42-page document. I'm going to link it in the comments below as well so you can follow along or go at your own pace. So here we are with now comes the defendant, Mr. Aiden Carney, by and through undersigned counsel, and hereby moves that the court dismiss all the 16 indictments before the court for a lack of probable cause that the crime was committed where the charges implicate only protected speech, and the prosecutor's impairment of the integrity of the grand jury by misrepresenting. So the prosecutor lied at the grand jury, the state's evidence, he lied about it, and the law. So he lied about the state's evidence and the law before the grand jury in a manner material to obtaining the indictments in violation of Articles 1, 10, 12, and 16 of the Massachusetts Declaration of Rights and the First and 14th Amendments to the U.S. Constitution and their progeny as set forth herein. And that's all a bunch of legal mumbo jumbo. All right, so Mr. Carney requests that each indictment be dismissed upon a written and published judicial declaration that the alleged conduct laid before the grand jury is protected under speech, uh, is protected speech under Article 16 and the First Amendment, and that the grand jury presentation was rendered defective by the special prosecutor's material distortions of fact and law, which was motivated by a clear conflict of interest arising from Mr. Carney's investigative reporting. So he's been blogging about this. He's been writing about this. He has over 500 articles, I think, at this point on his website about the Karen Reed case and key people within the Karen Reed case. So he's been reporting on that, and the Commonwealth has been weaponizing the law against him, an unconstitutional statute, to um, silence him from his very effective reporting because the Commonwealth doesn't want questions asked. That's pretty much it. He's asked questions. He's he's made some comments that he believes Karen Reed is innocent, and he has pointed some fingers at some potential other suspects, and he asked questions about the investigation, and that is okay to do. That is free speech, but not in Massachusetts, apparently. So Mr. Carney's background relevant to the motion to dismiss. Mr. Carney is an award winning investigative journalist who owns, reports from, and operates a number of news outlets that broadcast over the internet through YouTube, Facebook, X, and his own websites and web pages. He live streams news, investigates matters of public concern, and often breaks stories by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. He offers pointed and unapologetic commentary to his viewers, which numbers in six figures and cumulatively reaches into millions. He protests, urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, questions investigative targets, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides in depth, well sourced factual reporting, often accompanied by a call to action for justice and truth. The indictments against Mr. Carney stem from his investigative reporting on a pending homicide case in Norfolk Superior Court, Commonwealth versus Karen Reed. Ms. Reed has been charged in the 2022 death of Boston police officer John O'Keefe. Mr. Carney is an outspoken supporter of Ms. Reed who strongly believes that he was framed by numerous individuals, including members of the Massachusetts State Police who were prosecuting him, members of the MSP who are witnesses against him, and numerous civilian witnesses against Reed. So lots of conflicts of interest there. Mr. Carney's reporting on the Reed case, including his detailed series Canton cover up, has garnered national attention. And at present, Mr. Carney has published 465 articles. I believe he's over 500 now, maybe, possibly, or getting close. His reporting has broken several notable developments in the case, many of which involve the very witnesses he is alleged to have intimidated. Consequently, Mr. Carney's reporting and advocacy journalism have severely criticized the Norfolk County prosecutors and state police assigned to the Reed case, which, in turn, has led them to weaponize the Massachusetts witness intimidation statute against Mr. Carney with the intent to silence his criticism of their alleged misconduct in the Reed investigation and prosecution. Indeed, redacted electronic communications illustrate the Commonwealth's intent to silence Mr. Carney by exploiting the fundamentally flawed statute. I wonder if they're talking about Michael Morrissey's email communications, because remember he was using a burner phone and possibly talking to witnesses, trying to silence Aiden when Jen McCabe was texting him and saying, I'm disgusted by what happened today. And how come Aiden didn't get the restraining order or whatever? Or Chris, I think Chris Albert was who it was, like didn't get the restraining order. She didn't get her restraining order against him. And it's all because protected speech. So, indeed, electronic communications illustrate the Commonwealth's intent to silence Mr. Carney by exploiting that fundamentally flawed statute. Shortly before Mr. Carney's arrest, 4 months old conduct, so he was arrested for things that happened months prior to when he was arrested. Redacted, who was referred to Mr. Carney as an redacted, outrageously and recklessly texted, redacted, and 3 other unknown individuals redacted. You can make out what that means. You're smarter than I. All right. But I get it. Somebody texted something and it was probably maybe a Jen McCabe text or because I believe he has Jen McCabe's texts. He also has been receiving texts from or messages from Jen McCabe, which I think this gets into in further detail, so I won't give it away. All right, applicable law. The legal principles to be applied in the instant motion. Where did I miss this? I missed a footnote here, so sorry. Let's backtrack to wherever that footnote was. I cannot find it. Am I missing it? I can't see it. So I'm just going to read it. Okay. Proctor has a disturbing pattern of allowing his anger and emotions to impact his professional conduct. His shocking, misogynist, and cruel attacks on Ms. Reed are well known, resulted in his suspension without pay, and may very well result in his termination from the MSP. He referred to a medical examiner on the Reed case that he disagreed with as a whack job. He has referred to one of Ms. Reed's attorneys as an a hole. He also has described his hatred of another of Ms. Reed's attorneys when he said, so if you remember in trial, someone sent a picture of David Yannetti to Michael Proctor in that group text, and he goes, I hate that guy. So that was him saying he hated David Yannetti. Here, and most recently, we learned that Michael Proctor called Alan Jackson an a-hole in because he didn't want to watch his closing arguments because he was just as worried as everybody else, or whatever his text said. So that's probably what that is referring to there. All right, so legal principles to be applied in the instant motion to dismiss indictments concern the law of a probable cause in the grand jury, impairing the integrity of the grand jury by distorting the evidence in a manner affecting the indictment decision, and witness intimidation, picketing, and their First Amendment limitations where speech is implicated, and conspiracy. So all of those crimes sort of he has been accused of. So, uh, what do they say to the probable cause indictment? The grand jury performs the dual function of determining whether there is probable cause to believe that the suspect has committed a crime and of protecting citizens against unfounded criminal prosecutions. So they're kind of a second layer to making sure that prosecutors aren't maliciously or like unnecessarily going after people don't who aren't breaking the law or whatever. So, in that regard, that's what they are there for. And they're supposed to find or determine if there is probable cause in the case that's being presented to them, which then if they do, then that goes forward to trial if that's what the defendant wants. And then if not, then you can't indict them. So that's kind of how that works with a grand jury. Fundamental considerations of fairness require that a court dismiss an indictment where the grand jury receives no evidence of criminality on the part of the accused. Basically, they're saying there was no law broken here, so the indictment shouldn't stand. They should dismiss the indictment. In order to obtain an indictment, a grand jury must be presented with reasonably trustworthy information sufficient to warrant a reasonable person in believing that the defendant had committed the offenses charged. Probable cause requires more than a suspicion of criminal involvement, something definite and substantial. The Commonwealth must include information to support probable cause as to each element of the offense. Now, this was way, 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 way back when I first started my channel and started covering this. We went over the indictments for Mr. Carney. It was like a 70-page uh, indictment. It wasn't even a probable cause affidavit. It was more like, here's your charge, and here's a bunch of quotes and things that you said on your live shows, and here's some incidents of some things that we just made up out of context. That's pretty much what it was. So, um, they never even explained the probable cause as to each charge, which is what you are supposed to do in a probable cause affidavit. All right, so although courts ordinarily do not inquire into the competency or sufficiency of the evidence before the grand jury, a judicial examination of whether probable cause existed at the time of indictment is a clear exception to the rule. Here, the First Amendment protects Mr. Carney's speech and opinions about, so it is his protected speech, and they are opinions. His opinions, you can't charge someone for having opinions about a matter of public concern, such that there is probable cause of criminal activity. In short, Mr. Carney's speech is protected as a matter of law under the First Amendment and the Article 16 of Massachusetts. Further, principles of third party liability and their absence in their presentation firmly establish that the Commonwealth has failed to implicate Mr. Carney in any supposedly criminal activity sought to be attributed to him by third party fellow demonstrators, whistleblowers, or other internet posters or commentators. We have a footnote here that says Mr. Carney does not imply or believe that any of his fellow demonstrators or internet bloggers or commentators engaged in any criminal activity, and nor did he incite any criminal activity, but they're trying to say that he did by taking things out of context from his show. In any event, he would not be responsible for any such conduct, and nowhere in the grand jury was any foundation for joint venture liability ever referenced or attempted to be established. So it didn't even like meet the bar for him inciting violence or having other people complicit in his criminal activity. Grand jury indictments should have been dismissed where absence of evidence of knowledge and shared intent, consciousness of guilt evidence held insufficient to support indictments. Mere presence coupled with the failure to take affirmative steps to prevent a crime is insufficient for criminal liability. All right, so the next thing that they mentioned was impairing the integrity of the grand jury. The second instance warranting judicial scrutiny of an indictment concerns whether the prosecution has misled the grand jury with false or misleading evidence or statements. In order to show that the integrity of the grand jury has been impaired, warranting dismissals of the indictment, the defendant must be able to establish that false or deceptive evidence was given. This is so hard to. all the all the wording is on an angle, so it's very hard to highlight this. So I apologize for my crooked highlights. And that the page is crooked, that is just how I received it. So apologies. All right, so let me repeat that. So basically, they're trying to show that the integrity of the grand jury was compromised because the prosecutor gave false or deceptive information. So in order to show that the integrity of the grand jury has been impaired, warranting dismissal of the indictments, the defendant must be able to establish that false or deceptive evidence was given to the body knowingly or recklessly for the purpose of obtaining an indictment, and that the presentation of the false or deceptive evidence probably influenced the grand jury's determination to hand up what did it say? To hand up an indictment. Okay, that was just weirded oddly to me, sorry. All right, so here the prosecutor misstated the law to the grand jury and elicited improper opinion testimony from witnesses, conflated protected speech with illegal conduct, and failed to inform the grand jury about first indictment limitations on the speech that was sought to be charged. Although a prosecutor maintains discretion as to whether to instruct on the law, when he does, he must refrain from erroneous statements. So, when you are instructing on the law, you can't lie about it. By providing legal instructions, the prosecutor enables the grand jury to meaningfully apply the facts to the law, thus assisting the grand jury to fulfill its role as a bulwark of individual liberty and a fundamental protection against despotism and prosecution. Quoting Commonwealth versus Favuli, the prosecutor must scrupulously refrain from words or conduct that will invade the province of the grand jury or tend to induce action other than that which the jurors, in their uninfluenced judgment deemed warranted on the evidence fairly presented before them. So they shouldn't be clouded by, the jury shouldn't be clouded by lies or misconduct by the prosecutor. Here, as will be set forth below, the cavalcade of errors and opinions presented impaired the integrity of the grand jury proceeding and warrants dismissal of the indictments. Next point is witness intimidation involving speech is strictly limited to narrow exceptions to the First Amendment. The Commonwealth ignored such limitations in its presentation. The alleged witness intimidation charges concern Mr. Carney's reporting on the Karen Reed case, including his online updates, live shows discussing the case, appearances on demonstrations, and his expressions of opinions about the conduct of certain individuals in connection with the case. The witness intimidation charges at issue depend on certain conditions precedent, such as evidence that the alleged offender intended to mislead, offer a witness anything of value, threaten, harass, and attempt to cause emotional or economic harm. He never did any of those things. That's what witness intimidation um, is about. Offering a witness something of value, threatening, harassing, and attempting to cause emotional or economic harm. However, the First Amendment and Article 16 limit these potential violations when the alleged means of the crime is a person's speech. The Constitution demands that content-based restrictions on speech is presumed invalid and that the government bear the burden of showing their constitutionality. God, there are so many big words in this one, and I'm having a hard time with my tongue. All right, so the carve outs where speech may be regulated are few and narrow. In U.S. versus Alvarez, U.S. 709, the U.S. Supreme Court set forth the entire field of exceptions as follows. In light of the substantial and expansive threats to free expression posed by content based restrictions, the court has rejected as startling and dangerous a free floating test for First Amendment coverage based on an ad hoc balancing of relative social costs and benefits. Instead, content based restrictions on speech have been permitted as a general matter only when confined to the few historic and traditional categories of expression long familiar to the bar. Among these categories are advocacy intended and likely to incite imminent lawless action. See Brandenburg versus Ohio. Obscenity, defamation, providing that substantial protection for speech about public figures, imposing some limits on liability for defaming a private figure, speech integral to criminal conduct, calling fighting words, see Chaplinsky and New Hampshire. Child rhymes with corn, see New York versus Ferber, fraud. Okay, this is all very boring. All right, and speech presenting some grave and imminent threat, the government has the power to prevent. Although a restriction under the last category is most difficult to sustain, under the New York Times Company versus United States, these categories have a historical foundation in the court's free speech tradition. The vast realm of free speech and thought, always protected in our tradition, can still thrive and even be furthered by adherence to those categories and rules. Here, the Commonwealth merely alleges that the Reed witnesses and investigators suffered emotional or economic harm and or were placed in fear by Mr. Carney's exercising his First Amendment rights to report, question, demonstrate, and advocate on important matters of public interest, including arguments advanced in the Reed case that she was framed by the very people Mr. Carney is accused of causing emotional and economic harm. The First Amendment does not cease to protect a journalist's non threatening opinions simply because such speech allegedly has caused economic or emotional harm to a witness or other related person under the statute. Think about all the other people in the world who have been accused of something and the media goes after them before they've been arrested and ask them questions and thank Scott Peterson when the media basically camped out in front of his house all night. Thank the Brian Laundrie's parents, Roberta and Christopher. I can't remember his name. Laundrie, I think it's Christopher. And people were camped out. Protesters were camped out outside their house for weeks until finally, until finally Brian was found no longer alive. But they were protesting because they knew Brian was in that house and they wanted justice for Gabby Petito. So none of those people were ever charged. None of those people, I'm sure it caused stress emotionally on the Laundries. I'm sure Scott Peterson was stressed out, but do we care? No. Like that's not a reason to prosecute someone for speaking out about something that they think that you might have done. Anyways, all right. So the First Amendment does not cease to protect the journalist's opinions simply because such speech allegedly has economic or emotional harm to a witness or other related person under the statute. If anything, it is precisely in these situations in which the First Amendment must protect a person's right to report on and express their opinion on a matter of public concern. Alleged harassment by speech which purportedly causes another economic harm or emotional injury, which impedes or otherwise interferes with anyone connected to a proceeding or a proceeding itself, assuredly is protected speech from the First Amendment and therefore unconstitutional under O'Brien versus Borowski. Whereas here, words or expression form the basis of the alleged violation, only true threats or fighting words can be the target of the statute. So he didn't say true threats, violent words, nothing like that. It's all been Jen McCabe Googled 227 at 227 house long to die in the cold. Julie Nagel was in the house. Alan Albert was in the house. Those are all under protected speech. Unquestionably, all of Mr. Carney's opinions and expressions are exempt from the statute because they are not true threats or fighting words. In these circumstances, the Massachusetts Witness Intimidation Statute 268, Section 13B, which prohibits the causing of economic or emotional harm through non criminal speech, aside from true threats or fighting words, is unconstitutional on its face, which we've been saying from the get go. And it's unconstitutional as applied to Mr. Carney as well. So in Snyder versus Phelps, the U.S. Supreme Court illustrated how the First Amendment protects a speaker even where repulsive, non threatening speech may have caused substantial emotional harm to another. There, the family of deceased Marine Lance Corporal Matthew Snyder filed a lawsuit against members of the Westboro Baptist Church who picketed near his funeral while displaying signs that said, "Thank God for dead soldiers" and FAG troops, which I don't want to say that word. So, in reversing an intentional infliction of emotional distress judgment for the plaintiffs, the Fourth Circuit held that the highly offensive and cruel speech was protected by the First Amendment, notwithstanding the distasteful and repugnant nature of the words. So it doesn't matter how distasteful the words are, they're still protected. Furthermore, the Supreme Court has recognized that speech on matters of public concern is at the heart of the First Amendment protection. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That is because speech concerning public affairs is more than self expression, it is the essence of self government. Self expression is the essence of self government. Without Aiden putting pressure on the government, they'd be doing the same thing. We wouldn't have as much eyes watching what's going on in Norfolk County. So his ability to report on it and his ability to criticize witnesses in the case, investigators in the case, is what is giving this case more attention and the ability for possible justice in this case, because as it is now, there is no justice. You can't have justice for John O'Keefe if you are convicting the wrong person, and not just convicting her, but railroading her completely, making the case fit your narrative rather than following the evidence. And that is exactly what the Commonwealth is doing. All right, so accordingly, speech on public issues occupies the highest rung of the hierarchy of First Amendment values and entitled to speech or to special protection. Despite the abhorrent and gut-wrenching nature of the picketing, the fact that it was peaceful, non-criminal, focused on a traditional public forum, a public street, and addressed matters of public concern, the picketers were shielded from liability for infliction of emotional distress for their speech. So that is coming from Snyder, I guess. Um, so I don't think he's calling the this picket, the rolling rally, abhorrent. This is coming from, or talking about another case. It kind of threw me off there for a second. All right, so in O'Brien and versus Borowski, the Supreme Judicial Court addressed the Massachusetts criminal harassment statute and its inherent conflict between the protected speech of a defendant and its possible impact on an alleged victim. The court held that illegal harassment was limited to fighting words or true threats and interpreted the meaning of fear to mean fear of physical harm, of fear or fear of physical damage to property. So it doesn't have to just be fear of yourself, it could also be of your own property. In other words, this SJC has made it abundantly clear that an individual's claim that another's non-threatening speech has caused her to suffer emotional or economic harm and that they are in fear of non-criminal consequences may not be criminalized under the First Amendment. So if you're in fear of someone, you need to take that up with a civil court, get yourself an RO, not going to, or beyond that, not trying to say that it is some kind of, you know, witness intimidation. The O'Brien court decisively held that allegedly instilling subjective fear in a person does not give a prosecutor a basis to charge them. An intent to cause fear, however, is less certain to be consistent with a true threat unless we narrow what it is that must be feared. As the United States Court of Appeals for the Seventh Circuit noted, there are types of threats that may contain ideas or advocacy, such as a threat to picket an organization if it does not yield to a demand to take some social or political action. Such a threat may cause a fear of economic loss, of unfavorable publicity, or of defeat of the ballot box, but such fears cannot be enough to make a threat a true threat that may be prohibited as civil harassment under the First Amendment and Article 16. There is nothing in the language of the Act or in its legislative history to suggest that the legislature intended fear to mean more than the fear of physical harm or physical damage, and such the limiting interpretation would effectuate the legislative intent to confine the prohibited speech in the Act and to constitutionally unprotected speech. Therefore, we narrow the meaning of fear under the Act to mean fear of physical harm or fear of physical damage. So you cannot claim witness intimidation or whatever. This, you can't claim harassment if you're afraid of words, if you're afraid of economic harm. That does not count. Words being spoken, if you have fear of words being spoken that aren't an actual true threat to you, then you're threatened by what their person is saying. You're not threatened by that person per se. So there's a big difference there. The Commonwealth also elicited conclusory testimony that certain complainants, such as Elizabeth Proctor and Juliana Nagel, felt threatened. A threat is a legal term as defined under Massachusetts law and requires 4 elements as set forth in the model jury instruction. A threat to commit crime. The defendant is charged with having threatened to commit a crime against the person or property or the person or property of another. Threatening a person with a crime against his or her person or property, a person by threatening a crime against someone else or their property, is itself a crime. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond a reasonable doubt. First, the defendant expressed an intent to injure a person or property of another now or in the future. Aiden never did that. He never threatened to hurt anybody. He never threatened to hurt anyone now or later. Second, that the defendant intended that his threat be conveyed to a particular person. No, he never threatened anybody, so that's not the case, but he's spoken publicly about people in the case, but he's never threatened anybody, so that can't Aiden never did that either. And third, that the injury that was threatened, if carried out, would constitute a crime. So there was no threat. There was nothing that he said he was going to do to the individuals. So there was nothing that it constituted a crime. And fourth, finally, that the defendant made the threat under circumstances under let me start that again. Fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. Massachusetts District Court Model Jury Instruction, and that was revised January 2013. The third element demonstrates the lack of probable cause to sustain indictments on such a theory. So they've never even proven that there was a crime that was committed. The third element demonstrated the lack of probable cause. Mr. Carney's speech did not threaten injury from a crime and therefore do not run afoul to the Borowski rule. Rather, he expressed his opinion and common sense conclusion that people who lie may experience harm and discomfort, but he never threatened any criminal action whatsoever. And that is the huge distinction. He said things like your head might be on a swivel because people are going to be noticing you in public. That's not, that is a common sense conclusion, as his attorneys have stated here. So, in any event, under the First Amendment, even literal threats are limited as a basis for prosecution unless they constitute true threats. In Watts versus United States, Watts, at a public rally expressing his oppression to the military draft, said, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ." He was convicted of violating a federal statute that prohibited any threat to take the life of or inflict bodily harm upon the President of the United States. That, my friends, is a true threat. The Supreme Court reversed it, though, interpreting the statute with the commands of the First Amendment clearly in mind. So it is not a true threat, according to the Supreme Court. The court found that Watts' speech was protected under the First Amendment because he had not made a true threat. Okay, so it is not a true threat because it's an if I ever. But if he said, once I have a gun in my hand, I might do that. Maybe that's what would change it to a true threat. So this was not a true threat to assassinate President Johnson, but instead had indulged in mere political hyperbole. If a legal definition must be affixed, the words qualify as political hyperbole, where in light of its context did not constitute a knowing and willful threat and was protected speech. So if that is protected speech, why is Aiden's words not protected? If this person can say, if I was to do this, I would do this, how come that is protected, yet Aiden's saying you might want to watch out because people are going to know who you are now. You might not want to walk publicly on the streets as much, things like that. That's not a threat, though. That's a common sense conclusion. Thus, the offense of threatening to commit a crime only reaches cases of true threats. Commonwealth versus Sholey. The term true threats distinguishes between words that literally threaten but have an expression purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear. The true term, or the term true in true threats distinguishes jests, hyperbole, and other statements that in context do not convey a real possibility that violence will follow. That's the difference. And Aiden never incited any kind of violence against anyone. Applying recent U.S. Supreme Court case Counterman versus Colorado, holding that the First Amendment also requires the state to show that the speaker consciously disregarded a substantial risk that his communications would be viewed as threatening violence before it may punish him for conveying a true threat. The term true threat has been adapted to help distinguish between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. Thus, Mr. Carney's opinions may not be criminalized under a theory that he threatened anybody because his speech clearly does not constitute true threats. Here, all of Mr. Carney's outlandish statements set forth in the Commonwealth's presentation are well within the realm of political hyperbole, as well as satire and opinion, given the context and the conditional nature of the commentary. So if you don't take it out of context like the Commonwealth would want you to, you would realize the context surrounding it, everything that he's saying, it's all political hyperbole. He's an activist, as we've said. He likes to kind of stir the pot, but he's not stepping over any laws. He's not stepping over. All right. I don't know if my mic just cut out now or if it cut out prior, but I was noticing it didn't work, so I'm hoping that it was just when I tapped it just this moment. Ay, ay, ay. Okay, moving along. Let's continue. So, Massachusetts courts have also addressed these First Amendment protections, requiring Massachusetts judges to read statutes constraining political speech consistently. In Manalo the juvenile defendant was prosecuted under a statute proscribing the incitement of rioting. So a juvenile incited some riots. The SJC Justice Kafker writing held that Brandenburg versus Ohio limited the Commonwealth's proscriptions on political speech. Brandenburg involved a statute prohibiting persons who advocate or teach the duty, necessity, or propriety of violence as a means of accomplishing industrial or political reform, or who publish or circulate or display any book or paper containing such advocacy. The Supreme Court held that the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action. So even if you are advocating for using force or advocating for a riot, advocating for a rolling rally, that's still protected speech. But if you were to start telling people to incite lawlessness and produce such action, a statute which fails to draw that distinction impermissibly intrudes upon the freedoms guaranteed by the First and 14th Amendments to the U.S. Constitution. It sweeps within its condemnation speech, which our Constitution has immunized from governmental control. The Manalo M. Court analyzed the juvenile speech and found the same limiting principle obviously applies here. So the same limiting of principle obviously applies here in Aiden's case as well. There was no evidence before the grand jury that Mr. Carney called for imminent lawless action. No evidence. As opposed to engaging in satire, political hyperbole, and protected speech. Viewed in context and in light of the arguably more direct and alarming protected statements in the case law cited above, Mr. Carney's expression and advocacy are clearly political hyperbole, protected speech, and cannot form the basis to find probable cause that he committed witness intimidation. So there is no probable cause that he committed witness intimidation. Put simply, Mr. Carney did not urge imminent lawless action, and therefore the speech is protected by all foregoing precedent. Thus, the indictments lack probable cause that Mr. Carney committed witness intimidation to hold otherwise will afford the government authorities prosecuting Reed carte blanche to continue their distributing or disturbing pattern. So if you don't drop these indictments, you're going to give the prosecutors and the Karen Reed total control to be able to continue their disturbing pattern of exploiting the witness intimidation statute to suppress any speech that is critical of their conduct in the Reed case in the form of dubious content-based prosecutors. And we have a footnote here. The same prosecuting agency here has already attempted to normalize such prosecutions, bringing at least seven such witness intimidation and related prosecutions for placing rubber ducks bearing political messages around Canton in connection with the Karen Reed homicide case. Undersigned counsel has defended 5 such cases. So this particular attorney, Tim Bradel, has defended 5 cases in which there were witness intimidation statutes, all of which were not allowed to continue for lack of probable cause. 4 did not issue from court hearings, and the final, brought directly to arraignment, was dismissed by the Stoughton Court, Judge Walsh. The balance upon information and belief did not issue either. Prior to this, the Canton Police and the Norfolk District Attorney sought to prosecute the Canton Nine for demonstrating, and charges were again stopped by the court. The courts have been dropping these cases, yet Aiden's charges are still pending. Why? The statute as applied to Mr. Carney plainly violates the First Amendment, which requires the court to dismiss the charges against him and determine whether a narrower interpretation saves itself to conform to the First Amendment. This is exactly what the Supreme Judicial Court noted it would do involving the closely related criminal harassment statute in Commonwealth versus Welch, and what must happen here. In Welch, the court reversed a criminal harassment conviction and noted that if it was presented in the future with a speech case that contravened the First Amendment, it would be obligated to consider the statute and narrow its meaning to only proper constitutional parameters. Before we read that quote, let's go down here. There's a footnote that says the court found true threats, but not 3 in number as required by the statute. So you must have 3 true threats in order to be considered a true threat, I guess. All right, so here are the constitutional parameters. We believe the legislature, in carefully crafting the statute, intended the statute to be applied solely to constitutionally unprotected speech. Any attempt to punish an individual for speech not encompassed within the fighting words doctrine or within any other constitutionally protected category of speech would, of course, offend the federal and state constitution. So if you're trying to prosecute someone for anything that is not fighting words, not true threats, it's a constitutional it's impeding the constitutional rights of that individual. We decline to narrow the statute by engrafting into it a saving clause or other limiting construction at this time. Should the Commonwealth attempt to prosecute an individual for speech that is constitutionally protected, we would have no hesitation in reading into the statute such a narrowing construction to ensure its application only to speech that is accorded no constitutional protection. This is just that prosecution. The related witness intimidation statute at issue here flagrantly crosses the line, criminalizing unlimited speech that subjectively causes criminal or emotional harm or economic harm to a witness or other person listed in the statute. Let me read that again. That was a long sentence. The related witness intimidation statute at issue here flagrantly crosses the line, criminalizing unlimited speech that subjectively causes emotional harm or economic harm to a witness or other person listed under the statute. I read that better that time. All right, the court should dismiss the indictments, find the statute unconstitutional as applied to this case, and limit its reach to true threats and fighting words. At this time, I haven't checked the docket for today, but as of last night, the Commonwealth has not responded to this. But I think they have until today to respond to this. However, I don't know if they can because they're supposed to be arguing this tomorrow. So how can they respond with less than, 24 hours for the defense to be able to, react? So, and they should be able to respond to that once I think the Commonwealth is going to pull some BS so that arguments aren't heard today or tomorrow, I mean. But what was I going to say? Like in the past, they've been like, well, we're just, every single hearing just seems to be pushed further and further ahead in the future with nothing really happening because the Commonwealth is dragging their feet and not cooperating much. So now they're supposed to hear this. The Commonwealth may pull some bull like, oh, well, we didn't have enough time to respond, or we didn't respond, and we don't have enough time for whatever, and blah, blah, blah. I don't know. They'll try to pull something. And with Cosgrove now in charge of the case and the whole Mello thing, I don't know if Mello has officially been removed from the case. They might pull something there too. So who knows? Just be aware that something might happen where this motion doesn't get heard. However, at this point in time that I'm aware of, they have not responded, which means it goes uncontested, which means I believe that the court has no other option than to allow this motion to dismiss. We'll see. I mean, maybe I'm speaking way too early and the Commonwealth is going to drop a 400-page document tonight that the courts or that the defense isn't going to be able to read in time. So who knows? But as of now, that's kind of what is happening. All right, so it is respectfully submitted that if the court perceives any deference to an appellate court, it should certify the question to the appeals court under Mass Crim P 34, finding the issue of the statute's intrusion of fundamental rights so important or doubtful as to require a determination by a higher court. So if this court can't decide that this was unconstitutional and these indictments need to be dismissed, you need to send it up to a higher court because this is federal. This has to do with federal charges, federal protections of rights. So under the Picketing statute, non-criminal speech may not be used as a basis for establishing unlawful intent to influence witnesses. Only true threats and fighting words can withstand First Amendment scrutiny. again, with the only using the fighting words and true threats. So nothing Aiden has done would constitute that. The Commonwealth has abused the First Amendment through the state picketing statute GL 26-8, Section 13A, by criminalizing Mr. Carney's lawful speech and assembly in a traditional public forum, completely absent of true threats and fighting words or other criminal action. The statute provides, Section 13A says, whoever, with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge, juror, witness, or court officer shall be punished by a fine of not more than $5,000 or by imprisonment for not more than 1 year or both. Commonwealth's problem here stems not from a permitted time, place, and manner restriction, but from an overreaching attempt to use non criminal speech against Mr. Carney for establishing an unlawful intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty. In the First Amendment marketplace of ideas, non criminal speech urging someone to tell the truth, come forward, etc., can certainly influence a juror or justice, etc., and may obstruct or impede a proceeding. For example, a witness asks for more time to consult counsel and recant his lies, or refuses to further cooperate after giving in to urging to stop lying, or admits corruption and becomes a whistleblower. The statute's scope simply cannot be extended to non criminal speech in a public forum without sacrificing the First Amendment. Simply put, non criminal speech is allowed, even permitted. So, non criminal speech, which is what Aiden has done, is allowed, even permitted, and encouraged to impede, instruct, and delay anything it may by virtue of its rhetorical force without the risk of the utterance of being declared crimes. The Supreme Court so ruled in NAACP versus Claiborne Hardware that where they found that the picketers may be prosecuted for their conspiracy or other violation of valid laws, but it is a different matter when the state, instead of prosecuting them for such offenses, seizes upon mere participation in a peaceable assembly and a lawful public discussion on the basis for a criminal charge. Of course, the petitioners in this case did more than assemble peaceably and discuss among themselves their grievances against governmental and business policy. Other elements of the boycott, however, also involved activities ordinarily safeguarded by the First Amendment in Thornhill versus Alabama. The court held that peaceful picketing was entitled to constitutional protection, even though in that case, this Claiborne hardware case, the purpose of the picketing was concedingly to advise customers and prospective customers of the relationship existing between the employer and its employees, and thereby induce such a customers not to patronize the employer. So similar to Aiden Carney standing outside of D&E Pizza saying, um, buy the pizza at your own risk. There's blood on this is blood pizza, that's hyperbole. Obviously, he doesn't think that there's blood in the pizza. And he's saying that because he's protesting, picketing, and he's picketing Chris Albert rather than, the business or whatever, but that is Chris Albert's business, so he's picketing in front of a the individual's business, property, whatever, but it would still, the things that he said were still protected based on this. I don't know if you know what I'm talking about. There was a video where Aiden actually stood in front of D&E Pizza where he had this was like back in the old days when it was just him and his phone, and there weren't a lot of people around, and he was standing in front of D&E Pizza all by himself. He had signs, and he was saying, it's blood pizza and the like. And he wasn't really trying to deter customers, but he was saying it as, people were walking down the street and whatever. So there's that. All right, so in Edwards versus South Carolina, US 229, we held that a peaceful march and demonstration was protected by the rights of free speech, free assembly, and freedom to petition for redress of grievances. The picketing statute is unconstitutional on its face. So the Massachusetts the statute that they're using is unconstitutional on its face and as applied to Mr. Carney and, and must be dismissed as to each and every complaining witness under Claiborne. So because of all of that, every picketing, because he had multiple witness intimidation charges, some under the picketing statute, some under, some other thing. But for the picketing charge, there were multiple people. I know there was Jen McCabe, maybe Matt McCabe, possibly Proctor, because they went to those homes, and Julie Nagel. So those are the three that I think might have had picketing charges against. Maybe Elizabeth Proctor too, perhaps. I can't remember. So the grand jury presentation failed to present evidence of a conspiracy between Mr. Carney and Janelle Webb to commit witness intimidation. Janelle Webb, if you remember, this was way back before trial. This was even before Aiden was arrested. There was a photo that got leaked of a picture of Proctor's house with Jen McCabe's car in front, parked in front of it, with the Proctor's cars as well in front of their home. And she is the individual who looked up the license plate of Jen McCabe's white Jeep Wrangler and confirmed that it was registered to a Matt McCabe. So the Commonwealth charged Mr. Carney with conspiracy, and this is yet another charge. So he had conspiracy, picketing, and witness intimidation on some other reason. I can't remember what, but I think those were the three different types of charges. But he had like 14 charges. I can't remember because they added more, and it's all confusing. And there isn't one document that has them all. So there you go. All right, so the Commonwealth charged Mr. Carney with conspiracy to commit witness intimidation with Janelle Webb, an Avon police dispatcher who allegedly provided license plate information to Mr. Carney, which proved that Reed homicide case witness Jennifer McCabe visited the home of lead state police investigator Michael Proctor and wife Elizabeth Proctor, which flatly contradicted Proctor's claim that he did not know McCabe personally. But then at trial, they had to admit that they did know one another. Mr. Carney reported this bombshell development on his live show. This meeting was of such import that it became the subject of the cross-examination of Jennifer McCabe at Reed's first trial. Like I said, they had to talk about it at trial because it was such a big issue. There are 3 indictments alleging the conspiracy, listing Jennifer McCabe, Michael Proctor, and Elizabeth Proctor as alleged victims. Okay, so those are the conspiracy because they identified the Proctor house and Jen McCabe's car in front of it. So there must be probable cause that the defendant joined with one or more persons to do something unlawful or use unlawful means for a lawful end, and that the defendant joined the agreement knowing the unlawful plan and intending to help carry it out. Mr. Carney and Webb face an indictment for a conspiracy in search of a crime. It is not a criminal offense to run a license plate. Further, and she was never charged. She was, I believe, indicted, but she was never, they never uh, arraigned her, I don't think, and they never formally uh charged her, I don't think. Or yeah, I don't know if they actually charged her or not. They threatened to charge her for sure. I'm not sure if they actually did, and if they did, they never moved forward on it. It's still pending. So nothing's ever moved forward on that. So further, there is no evidence that Ms. Webb and Mr. Carney shared the intent to intimidate any of the three listed complainants. Further, or rather, the evidence before the grand jury demonstrates, if any, that Webb violated a user agreement as a trained user of the system. So, because she worked for somewhere for the city of Canton, she violated her employee agreement and therefore I believe she was fired. Notably, Webb has never been arraigned. Okay, good. She's never been arraigned or in any way brought to court for this conspiracy charge, which was handed down over a year ago. So, again, so she was charged but not arraigned, and that was over a year ago. They've never acted on it. Thus, there is no other person with whom to conspire to intimidate, and no evidence Mr. Carney intended to intimidate Jennifer McCabe and the Proctors with this newsworthy and embarrassing scoop. So it's not like he was trying to intimidate them, he was reporting. It's something he was reporting on. Even if Ms. Webb had engaged in illegal conduct, the Supreme Court's holdings protecting journalistic publication of whistleblower information. Blah, blah, blah. I need a break. My lips are, or my tongue is. Blah, blah, blah. So again, there are Supreme Court protections for whistleblowers and journalists who are reporting something that a whistleblower is bringing to them. So even if there were some kind of conspiracy, which there isn't, they'd be protected. All right, so in matters of public concern or importance, upholding journalists' right to publish stolen or leaked information. There was great public importance to verifying the presence of McCabe's vehicle at lead investigator Proctor's house. 1 month prior to the incident, in late August of 2023, District Attorney Michael Morrissey issued a video statement claiming unequivocally that Proctor did not know of any of the witnesses vouching for his impartiality in the Reed investigation, which we now know is a lie. The presence of McCabe's car at the Proctor house in the evening for a social visit suggested that Proctor and McCabe collaborated their testimony. It also eviscerated D.A. Morrissey's public statement, that it did, in which he vigorously defended Proctor and McCabe. Therefore, Morrissey's own office charged Mr. Carney with a baseless charge of conspiracy in retaliation for Carney proving the corrupt relationship. Damn, they write these things so good. I love it. Bradle, Yannetti, Allen, Eliza Little, who's the Alessi, am I missing someone? Betterow. They all have a fabulous way with words, and that is why they went into the profession that they did. For these allegations, Mr. Carney's disclosure here is completely protected by the First Amendment and its progeny. The prosecutor impaired the integrity of the grand jury by misrepresenting fact and law, soliciting opinion, and distorting the state of evidence by selective omissions, and the indictments must be dismissed. Prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. However, the integrity of the grand jury proceedings has been impaired, and a dismissal is warranted where the omitted exculpatory evidence would likely have affected the grand jury's decision to indict. If the grand jury were not aware of circumstances which undermine the credibility of evidence that is likely to have affected their decision to indict, then the appropriate remedy may be dismissal of the indictment. See also Odell. The withholding of a portion of the defendant's statement distorted the portion that was repeated to the grand jury. So I want to repeat that because this is important. Because not providing the full context of Turtleboy's comments is exactly what the Commonwealth has done, and trying to almost make it seem more, nefarious than it was. So this right here is really important. The withholding of a portion of the defendant's statement distorted the portion that was repeated to the grand jury in a way that so seriously tainted the presentation to that body that the indictment should not have been allowed to stand. Basically, all that means is they distorted the facts, the truth, whatever, so badly that the jury didn't have the truth, didn't have the full weight of the context involved, and therefore it changed the meaning. And the juries didn't have the full context, if that makes sense. So the prosecutor's repeated selective omissions here qualify as grounds for dismissal. So all of the context that would help support Turtleboy in his claims that he's not intimidating anybody, he's not harassing anybody. He's talking about a case. This is all political speech, and it's protected, and there's no reason why we should be here. Odell and its progeny require dismissal of the indictments due to the prosecution's impairment of the integrity of the grand jury proceeding. The transcript reveals the prosecutor's repeated and improper references to the conduct of others as a basis for wrongdoing by Mr. Carney. So this is Mello we're talking about, I believe. Mr. Ken Mello, who is MIA. He's been very, very sick. Once some allegations of his misconduct came forward, he has been MIA. And we are told, or were told in a hearing by Mr. Cosgrove, who is now the new attorney on this case for the Commonwealth, we were told that God might take care of that Ken Mello problem. Oh, maybe he is dying. I don't know, but it would appear that Cosgrove kind of has a sense of humor about it. But anyways, all right. So for example, at transcript dated December 5th, pages 23 through 28, Jen McCabe sweepingly asserts without evidence and speculates that Mr. Carney is responsible for the alleged actions of others. He brings people with him. They take pictures, they stop and they yell and they take video, they send it to him. It's almost like they get rewarded. There is no basis for joint venture liability addressed anywhere in the grand jury, yet the prosecutor repeatedly includes other group behavior suggestive of guilt without evidence linking the behavior to Mr. Carney. So they're trying to make it seem like he's inciting all these people to do all these things to the McCabe or to Jen McCabe and the McAlberts and all of the people involved, when in reality no one's telling anybody to do anything. We're just paying attention to the facts of the case, and we have eyes and common sense. So that's kind of what's happening. But anyways, so there is no basis for the joint venture liability addressed here. McCabe refers to actions of followers of Mr. Carney. I don't know if one of his followers is going to show up. They text me, they email me. There are repeated references throughout the testimony implicitly assigning blame to Mr. Carney for behavior of alleged followers, meaning this could be all made up, and even if it's not, he's not responsible for other people's actions. So if Joe Schmo goes over to Jen McCabe's house and, you know, destroys her front lawn, teepees everything and digs up her flowers and whatever, tears up her mailbox, whatever, like totally destroys your front lawn. That would be criminal charges on Joe Schmo, not, even if he's a follower of Eden Carney, that would be not on Eden Carney. That would be on Joe Schmo, the person who went there and actually did it, even if he did it because he was a follower of Turtleboy and listened to Turtleboy's reporting and became so incensed and enraged that he had to go over there and destroy her front lawn. I'm just saying, as an example, this obviously didn't happen, but that's Joe Schmo would get the blame and the criminal charges, not Aiden. So why is he getting charged for words that he's saying when other people go and take a picture of the McCabes? When that's what she doesn't like, is that people talk trash to her or take a picture of her, and she can't control that narrative. But that's not Aiden's fault. So at page 35 of the same volume, McCabe alleged without curative instruction that followers of Mr. Carney emailed her that she would be AR'd on her lawn and sent sexual messages about her daughter. As deplorable as that conduct would be if true, which we don't even know if that's true, the prosecutor should not have allowed that prejudicial evidence to be offered against Mr. Carney. And was there even ever any evidence that any of this ever happened is an even better question, because if not, then that shouldn't have been brought in. Also, another reason why it shouldn't have been brought in. By allowing such prejudicial and inadmissible evidence to be received against him, the prosecutor impaired the integrity of the grand jury, because such prejudicial evidence may have resulted in Mr. Carney being indicted for the alleged actions of others. Elizabeth and Michael Proctor did the same. See December 14th, 2023, volume at page 34, line 8. She refers to Mr. Carney's followers sending her emails and targeting her children without a curative instruction. Michael Proctor complains that protesters parked on his lawn and spit at his house while driving without any proof that Mr. Carney directed such actions. So they're blaming in their indictment for Mr. Carney, they're saying these protesters happened to go past a lawn and spit on Michael Proctor's lawn, which isn't a crime, by the way, but for some reason that becomes a crime for Aiden. That makes no sense. Here we have a footnote that says Mr. Carney reviewed the footage of the rolling rally and saw no such behavior. And there's also video footage of him telling everybody stay off the property. There's a no trespassing sign. Everybody stay on the road. So there's even video of him saying that. And at the last session, on December 20th, 2023, the prosecutor instructed the grand jury on the witness intimidation charge about addressing the First Amendment limitations on the alleged speech at issue. The prosecutor failed to instruct the grand jury on the limits related to any alleged harassment that served as the basis of the allegations. The prosecutor failed to address the First Amendment protections, which protects speech constituting political hyperbole, which he's already gone over in detail, which is completely protected. He did not instruct the grand jury on issues related to incitement to imminent lawless action, opinion, satire, and the necessity to find true threats or fighting words whenever First Amendment speech is concerned. So they didn't have the correct instructions to make the correct or to make an informed decision, let's say. Instead, the prosecutor repeatedly mischaracterized Ms. Carney's speech as actions or conduct. The omissions created a foregone conclusion of indictment and deprived Mr. Carney of the right to have the grand jury consider the proper treatment of speech and First Amendment limitations to the prosecution. If they had known so remember, a grand jury does not have a defense attorney present. So it is the prosecutor and the grand jury. The prosecutor presents evidence and it is not disputed. But it is also the prosecutor's responsibility to present exculpatory evidence and to instruct the jurors on the law, which he didn't do properly. Now I don't know where I left off. The prosecutor repeatedly mischaracterized his words as actions, and conduct. The prosecutor also impaired the integrity of the grand jury by eliciting improper opinion and hearsay. For example, the prosecutor impermissibly expressed his personal opinion that Julie Nagel was a victim. At the end of her testimony, she is questioned by Mr. Carney's online reporting, in which He simply exhorted Nagel to tell the truth without making any threats or issuing fighting words. Rather than present evidence of Mr. Carney's actual intent, the prosecutor improperly asked Nagel her opinion of Mr. Carney's intent. In your opinion, is he trying to get you to change your testimony? And she said, yes, correct. How is that even allowed? Suggesting wrongly that the content supports a witness intimidation charge when it obviously does not. With respect to Elizabeth Proctor, see December 14, 19, what? 2023 transcript, page Page 26, line 3, the prosecutor asked Detective Tully his opinion of Mr. Carney's intent. Any other incidents that you feel were intimidating to Elizabeth Proctor? And the detective answers, without reference to any evidence from Elizabeth Proctor on the point that Mr. Carney was protesting to the neighborhood, giving the reader no idea whether she was intimidated by it and whether the alleged fear experienced was within Brian or Borowski or protected speech. The repeated reliance on opinion is again a directive from the prosecution to indict and warrants dismissal. So they shouldn't be, the grand jury shouldn't be indicting people on other people's opinions of what may or may not have occurred because it's not fact. It's not based on anything. The repeated use of multiple police officers and civilians to express their inadmissible opinion of Mr. Carney's intent may have infected the proceeding by leading the grand jurors to credit inadmissible opinion evidence on Mr. Carney's intent as a basis to believe that every witness shared the view of Mr. Carney's intent. Finally, improper opinion and hearsay testimony was used to falsely establish a conspiracy between Mr. Carney and Avon police. I don't know if you say how you guys say it. To me, that's Avon, like Avon calling, but I think it might be Avon. Avon. Yeah, I don't know. Anyways, so police dispatcher Janelle Webb. This conspiracy between Carney and Janelle Webb. The prosecution failed to present any evidence that Ms. Webb and Mr. Carney conspired to engage in criminal conduct. Uh, Accessing the license plate was not a crime, and in any event, there was no evidence before a grand jury that Webb obtained the information with the joint intent to commit witness intimidation. She just kind of took it upon herself to do so, and got, confirmed that it was owned by Matt McCabe. Instead of seeking to introduce admissible evidence in support of this allegation, the prosecutor asked Trooper Fanning, "Is it fair to say that in your opinion that she conspired with Mr. Carney to disclose the information in those queries and to have them published online?" He says, "Absolutely." That's garbage. These errors, combined with the prosecutor's erroneous instructions to the grand jury, impaired the integrity of the grand jury proceeding and renders the indictment defective. Next point is, taken in turn and viewed in light of the legal principles set forth above, each alleged victim's testimony fails to establish probable cause for witness intimidation, picketing with unlawful intent, and conspiracy, and the indictments must be dismissed. In their vendetta against Mr. Carney, the dual Carney-Karen Reed investigators were clouded by conflict of interest and desperate self-protection. To shut down Mr. Carney, they invented a new crime, witness intimidation by journalism, invented unlawful intent to influence from peaceful protest or from peaceful protected speech to prop up picketing charges, and speculated that Ms. Webb conspired to intimidate when she was simply a whistleblower, and Mr. Carney was a journalist protected by the First Amendment publishing newsworthy information. Each of these unprecedented attempts to saddle Mr. Carney with criminal behavior was an unmitigated failure. Each alleged victim will be referenced in turn as follows: Michael Proctor, MSP lead investigator, Karen Reed, homicide case. The evidence relating to Trooper Proctor was that Mr. Carney called a phone number which was made publicly available in a Reed case court filing, and it turned out to be the trooper's cell phone number. Mr. Carney was calling numbers from witness Jennifer McCabe's publicly filed call log and was shocked, exclaiming, "Oh my God, it's Proctor." Mr. Carney was investigating who Miss McCabe was calling. Mr. Carney was investigating what people Ms. McCabe was calling. See message aired in real time, episode 590 on Mr. Carney's live show, offered as a video within example 2 thumb drive or exhibit 2 thumb drive, and read to the grand jury at the December 5th transcript. Left a message seeking to ask him questions. Mr. Carney left Proctor a message seeking to ask him questions that were of public concern, stated matters of his opinion of the Reed case, employed satire and political hyperbole, but never uttered any threats or fighting words. Because Mr. Carney was sharing the public court documents on his screen to analyze it for journalistic purposes, Trooper Proctor's number was seen by the audience. There was never any felonious witness intimidation, only a time honored exercise in smart investigative journalism, connecting the dots and following the evidence between witnesses calling each other in the Reed case. The fact that the number already published in a court filing was released does not criminalize the actions, nor do the actions call from third parties to Proctor's number, allegedly causing Proctor to get a new number. They're claiming that because he read Proctor's number online and then he called it, and other people then started calling it, and then Proctor had to get a new number for that reason. But that is, again, not Aiden's fault if other people were calling it, because it is on a public line. He just happened to discover it on a live. It was pretty fun to watch. All right, these are not legally assignable. So even if other people were calling him after his call, these are not legally assignable to Mr. Carney in truth or on the evidence presented. We have a footnote here that says, if this is a crime, the prosecutor is guilty of the same. You might remember Mello published some people's numbers. After the indictments and Superior Court arraignment, the Commonwealth Prosecutor Mello published the cell phone numbers of Attorney Bradel and 2 paralegals assisting Mr. Carney on the front page of a public court filing, causing the paralegals to receive vulgar and alarming text messages, and Attorney Bradel to have his email account hacked and password altered after the number was used as a security entry the same evening of Mello's publication. The defendant's motion for sanctions and disqualifications remains pending and on the docket, so they have asked for sanctions and disqualification of Ken Mello, which still has not been argued because they've been pushing it off, and then he got sick, and now it is what it is. All right, so there is no evidence whatsoever of any intent to cause physical injury or property damage to Proctor within the O'Brien versus Borowski limitations, or emotional or economic injury, which is unconstitutional for that matter. The speech is protected by the First Amendment. Proctor also testified about the July 2023 rolling rally protest in Canton. He was not home, but he testified that he observed that the MSP video recorded the rally and he viewed the footage. Really? So MSP, Massachusetts State Police, were like following them around? Is that it? So how did they get the footage of this rolling rally? He noted no damage to anyone's property, no testimony about any charges arising from the video recording, and a complete absence of actionable criminal behavior from demonstrators peacefully exhorting witnesses to tell the truth. So basically, like, no crime took place. And Michael Proctor testified to as much. Mr. Carney was the only person charged arising from the rally. The prosecutor craftily sought to implicitly assign blame to Mr. Carney for vague, alleged criminal conduct of third parties, allegedly spitting out their window and parking on his lawn. It is notable that no such video was introduced in the presentation and none is known to exist from discovery. So, this MSP video that he says he saw has never been turned into discovery. It's never been turned over to the defense. They've never seen anything. There's no like ring camera footage or anything from Proctor's house of people on his property. Nothing. So, how are they basing their argument? Mr. Carney digitally records the rally and provides a clip from the rally where he warns about a no trespassing sign and a turtle crossing sign on Proctor's lawn. See rally clip filed under separate cover with instant motion. Proctor lied about criminal behavior and also admitted he didn't even know what Mr. Carney was saying at the rally, and that he didn't know Mr. Carney's motivations or intentions. So if you didn't know that and you didn't think his intentions were nefarious, trying to get you to change your testimony, then what's the problem here? Why was he charged for Proctor? Finally, Mr. Carney has reviewed the Canton Police call logs from July 22nd, 2023, the date of the rolling rally, I believe, and found not a single call to police to report anyone involved in the rally. So, not a single call. There was no rational proof of any unlawful intent to influence testimony as required by the Picketing statute, only lawful First Amendment protected non criminal speech. Redacted also revealed the improper motives for affecting, I think that's mellow, the improper motives for affecting Mr. Carney's arrest in text messages provided in discovery. In a September 3rd, 2023 group text message in discovery, redacted, so and so admits that his motivation for having Mr. Carney arrested is redacted, that he is employing political hyperbole and satire under the First Amendment without writing under the First Amendment, writing about redacted and intimidating him or trying to obstruct justice is only a false pretext used to silence him. Therefore, in a July 13th, 2023 email to Redacted, calls Mr. Carney a Redacted, called him and asked Redacted, again shows that the motivation for arresting Mr. Carney wasn't for intimidation, but for personal revenge. I think, oh, that might be Tully. That might be Brian Tully here that they're talking about. I don't know. Brian Tully might have been the one seeking out personal revenge because Aiden was reporting on MSP troopers and Tully himself. So I'm speculating there. I don't know, but it potentially might have been Brian Tully or Mello or somebody who misrepresented something there. Here's a footnote that says in January 2025, so this year, Trooper Proctor was the subject of a state police review board inquiry facing possible termination for misconduct in Karen Reed investigation. The decision is pending as of the date of this motion. He was put on unpaid leave 4 months prior to this hearing. He was actually put on unpaid leave very shortly after the trial. I want to say it was like July 8th and July 1st is when trial ended. So I think he was put on leave very, very soon. All right, so Elizabeth Proctor, wife of lead investigator Proctor. Mrs. Proctor is the wife of Trooper Proctor. Her testimony epitomizes the defective nature of the presentation by the prosecutor. Her transcript is replete with complaints about the actions of other followers, aside from the defendant, with the implicit suggestion that Mr. Carney is legally responsible for the complained on behavior or speech, with disingenuous suggestions about Mr. Carney's intentions, that he is clearly engaging in online political hyperbole, satire, or opinion with baseless and conclusory claims that defendant is threatening, and again with improper opinion. So she's saying he's threatening her, she's saying his followers are doing things, again, all stuff that shouldn't have come in because none of his words have ever been threatening and everything's been protected speech. So Mrs. Proctor admitted calling an online commentator's workplace, trying to get them fired for speaking about her husband. In the grand jury transcript dated December 14th, 2023, she admits, "I acted out and targeted one of Mr. Carney's followers who was coming at me online, posting online, and called the employer of them. And it was obviously not the right thing to do." So she's saying, I don't believe this, she thinks it's wrong, but I think she's only saying that because she's in court. Mr. Carney was investigating a matter of public concern. The wife of the lead investigator in the Karen Reed case was trying to punish people exercising their First Amendment rights, commenting online about her husband's alleged corruption by getting them fired and or bullying them at work. So anyone that was speaking about, or criticizing her husband in a public forum, she was trying to get them fired or bully them at work. In Mrs. Proctor's world, she may seek to inflict economic harm on whomever she wishes, but Mr. Carney must endure a felony prosecution because he is investigating corruption and matters of public concern. Can you say hypocrisy? There's so much hypocrisy in this state. There's so many double standards in the state of Massachusetts in this case when it comes to the witnesses and the defendants, in this case and Karen's case. So in the grand jury, Mrs. Proctor continued her ill-advised campaign to punish her enemies by lying about Mr. Carney. She stated Mr. Carney has been threatening, and she resorts to pulling emotional strings by referencing her children. The reality, as shown in the video proffered by the Commonwealth in support, shows that Mr. Carney expresses only his protected opinion about Proctor's actions and clearly employs protected political hyperbole and satire to underscore the seriousness of police corruption by claiming, absurdly, that he is going to take custody of their children when Trooper Proctor goes to jail for misconduct. Obviously, in no rational world is this a true threat or fighting words uttered across cyberspace. Yet, with a straight face, the prosecution and the witness seek to sell the grand jury on the notion that Mr. Carney's threatened to harm my children and take my children. So clearly that is they keep twisting his words and using his hyperbolic and smartass type of language, and they twist it and make it like he's actually threatening them when in reality it's protected speech. Just like in Watts, the context and inherent absurdity of the claim, as well as the political and public concern on the content, all conclusively contribute to the conclusion that the speech is protected. O'Brien also thwarts any prosecution here where her fear is not of a crime being perpetrated, but again, absurdly, fear that Mr. Carney would engage in a child custody proceeding and have custody of her kids while her husband does hard time. Like, that's even possible. Like, he even has any standing for her kids, nor would he want them. Like, come on. The one Elizabeth Proctor indictment here for witness intimidation must be dismissed. Next one, Jennifer and Matt McCabe. Ms. McCabe is a Karen Reed witness who Google searched on her phone "house long to die in cold." Out of the more than 4,500 searches she conducted on her phone, a defense expert found that this search was the only search that she ever deleted in the lifetime of her phone. A hotly contested issue in the Reed prosecution involving a battle of experts involves the time of this search. If she performed the search at the time stamped 2:27 a.m. as is claimed by the defense, this would constitute powerful evidence of her involvement in a cover up of the homicide of John O'Keefe. The prosecution claims she entered the search after 6 a.m. at Ms. Reed's behest when Mr. O'Keefe was discovered near death in Brian Albert's front lawn. Mr. Carney strongly supported the defense position of 2:27 a.m. and has extensively written and reported on the issue. Trooper Tully encapsulates Mr. Carney's interactions with Ms. McCabe. Ms. McCabe spoke out over Mr. Carney's investigation of her, texting the district attorney and the prosecutors demanding action. She also sought a Stoughton District Court criminal harassment order against Mr. Carney, but was rebuffed. See docket filed under separate cover, so they provided it as an exhibit. See clip of hearing filed under separate cover. That was also I know there was audio of it. I don't know if Aiden ever got video of it, but we've seen the audio, or he played the audio of it on his channel, both of Chris Albert and Jen McCabe's restraining order hearings, and they both led to a denial. So at this hearing, Ms. McCabe showed that the case was not about witness intimidation, but about her silencing Mr. Carney's reporting about her involvement in the homicide of John O'Keefe. She says, quote, "Is there anything you can do to get him to stop blogging about me?" And I believe he used to have a t-shirt that had that on there. I don't know if you can still buy it from his merchandise, but Turtleboy had a shirt, I think, that said, "Can you get him to stop blogging about me?" And the judge demurring and declining to issue order of on First Amendment grounds. Significantly, the prosecutor did not disclose this adverse decision to the grand jury. So basically, Ken Mello was like, "I'm not going to tell the grand jury about the fact that Jen McCabe tried to get a restraining order and it was denied due to the fact that the judge said everything was under his protected speech rights." So there you go. Finally, it is important for the court to consider that the fact that Ms. McCabe has been protected and not charged in the case does not criminalize Mr. Carney's reporting on her involvement. Reporters often are ahead of the story, anticipating that law enforcement will actually follow the evidence where it leads and act accordingly. So just because she hasn't been charged yet doesn't make it a crime for Aiden to ask her questions and to put pressure on her. It's not a crime. Once again, the prosecution fails in establishing any criminal behavior on the part of Mr. Carney. The evidence adduced shows that only dogged investigation journalism with impolite or distasteful and perhaps juvenile invectives, but also involves matters of extreme public concern focused on the cover up of the homicide and the the potential complicity or at least shocking incompetence of the state police. So basically, he's saying that because because of the type of case that Karen Reed is, because it's about the cover up and the corruption of law enforcement and prosecutors and judges and DAs and all that, it needs someone who's not conventional, who's going to go in there, do this kind of putting pressure on them by asking questions, going to the places that they are, showing up in their faces, asking questions. That's journalism. And that's the type of journalism that is needed specifically in this case because it is so rampant with possible, I say possible, but I believe it's total corruption. All right, so it is not unique or uncommon for a journalist to follow or confront a subject in public or to go to their door and ring the bell seeking answers to important questions. It is certainly not criminal on its face and especially not when viewed through First Amendment lens. Yet, all of these words and instances are reportedly used in the prosecutor's presentation and implicitly offered as grist for the indictment mill. Here, once again, Mr. Carney never used threats or fighting words, was asking questions about her extremely suspicious behavior, and expressing his protected opinions on the case and the culpability of various actors. Hurt feelings are legally, let me repeat that, hurt feelings are legally immaterial. Jen McCabe's feelings might be hurt, I think it's more so she just wants to silence him because it makes her look bad. But that still goes back to her personal feelings. And they're not worthy of an indictment. So using them for an indictment is unconstitutional. Her hurt feelings. All of this is First Amendment protected as set forth, and no state statute can criminalize such speech beyond these protections. The actors may civilly sue for libel, defamation, and the like, subject to truth, First Amendment, and opinion defenses, but the realm of criminal prosecution is unavailable for non criminal speech. So you cannot prosecute someone criminally for speech that is not criminal. I mean, it doesn't get clearer than that. Reporters address suspects and witnesses all the time, demanding, shouting, and repeatedly pressing requests for answers and whether they are guilty. This happens with um, government officials all the time. If you go to Congress or the Senate, well, not in most recent years, but in years long ago, the people who represented the media did ask questions like this. They were more investigative, especially back in like the 70s, 80s. But something definitely changed, and no longer the media is no longer reporting or doing their due diligence. So, anyways, so Carney did nothing above and beyond such speech. Reporters address suspects and witnesses all the time. Okay, I did say that. All right, so McCabe claimed to the grand jury that she made Mr. Carney aware she wanted him to stop questioning her without any supporting details. Mr. Carney denies any such communications. See affidavit of Ian Carney adopting factual assertions herein. McCabe is on video. See Commonwealth's Grand Jury Exhibit 1, McCabe Jennifer, when she is questioned at the Billerica? Billerica is how you guys pronounce it. Billerica. The Billerica lacrosse game, laughing and treating the episode like a joke, and never tells Mr. Kearney not to question her. So she's just sitting there laughing, smiling, and Matt McCabe is actually putting his hands on Aiden, trying to push him and get him out of the way and to leave. Like he is physically touched by Matt and I think one other person while he's there. So that is assault. And they were trying to like push him and push his phone out of the way. In fact, Matt McCabe shows she is not sorry, no, Ms. McCabe. Jen McCabe shows that she is not afraid of or intimidated by Mr. Carney, who she repeatedly taunts online. On May 10th, 2023, McCabe reached out to Mr. Carney sending him a bizarre half-naked photo saying, "Ha ha, it's your boy John C." 20 days later, McCabe went to the Stoughton court on May 30th, 2023, seeking the restraining order. She's the one sending weird things to him. McCabe unsuccessfully claimed she is in fear under the statute, and then only 10 days after that, on July 1st, 2023, she again engages with Mr. Carney online saying, "Sorry to bother you, have fun in Mashpee," indicating that she all apparently knew his whereabouts. So he was in a town outside of his regular whereabouts, and she knew where he was. Basically, sending some kind of an intimidating threat like, "I know where you are, buddy. Have fun." So who's intimidating who here? There is clearly no intimidation or emotional distress afflicting Mrs. McCabe, who initiates and enjoys wrangling online with Mr. Carney. Ms. McCabe, like the state police and the prosecution, only wants to use the system to silence him and will say anything to get her way. Redacted also enjoys unprecedented access to the redacted himself. She has direct text access to Redacted's cell phone, as shown in her impoundment text message. Redacted complaining that Redacted. I'm just reading what's on the page. Let's skip down to this here. Oh, okay. Good. More redactions. This motion is redacted, a redacted motion omitting this information. So, whatever. This is probably why it was a big part of why it was redacted. I wonder if this has to do with the fake victim, but I'm not sure. Anyways, so Ms. McCabe wishes are clearly a motivating factor in the improper effort to silence Mr. Carney through these unlawful indictments. Or maybe it was Ms. McCabe talking to someone else and that someone else isn't a witness, or I don't know, has some privacy rights there. So perhaps. So, in any event, a reporter pursuing witnesses on matters of public concern is entitled to keep trying as long as he engages in lawful conduct, and his non criminal efforts to do so are protected under the First Amendment. At the rolling rally, McCabe admitted that she did not call the police and suffered no damage of criminal conduct against her. See grand jury transcript. Where Mr. Carney engaged in non criminal speech and was covering matters of public concern, there can be no witness intimidation or unlawful intent. Jennifer McCabe's husband, Matthew McCabe, is also a supposed victim of witness intimidation and picketing with unlawful intent from the same encounter with Mrs. McCabe and from the July rolling rally. A view of the confrontation, which is in quotes because it really wasn't a confrontation. Like, Aiden was he confronting them with questions? Okay, I guess if you want to go there, but the only real confrontation was Matt McCabe trying to push him out of the way. So a view of the confrontation in the Billerica lacrosse game cited by the prosecution and introduced within Exhibit 1 shows no threats or fighting words uttered by Mr. Carney, but rather shows that Mr. McCabe approached and confronted Mr. Carney and that he certainly was not intimidated by him. Rather, the video clearly shows that Mr. McCabe is not intimidated in the least and he is the aggressor, that he bumps Mr. Carney, who is trying to ask questions, and that he says, he greets Carney by saying, "How's it going, tough guy? I didn't realize how small you were." So he comes right in like with the insults and the name calling and whatever, and Aiden's there to ask questions, but the people being confrontational are the McCabes, who are saying, "Oh, we're victims here. Get out of here." On the issue of intent and motive on the part of Mr. Carney, Mr. McCabe testified that I don't know what the point was about Mr. Carney's investigative efforts at the Billerica outside court. The prosecutor asked him, "Do you have any sense as to why Mr. Carney is doing this?" And McCabe stated that the reasons are building his profile, building his following, and working as a mouthpiece for the defense to taint the jury pool. Where did he get those ideas? McCabe doesn't mention anything about the defendant trying to influence his testimony. No, he did not. So, how is that intimidation, witness intimidation? Even when he is led and coached by the prosecutor asking, "What is his purpose directly with you?" He says, "We're the witnesses," but doesn't mention any perception of influence to his testimony. Once again, it is clear that with respect to Mr. McCabe, Mr. Carney uttered no criminal speech and is as protected against the husband as he is of the wife. Regarding picketing with unlawful intent for Mr. Carney's presence in the McCabe neighborhood at the July rolling rally, the allegations surrounding that episode are equally unavailing. Mr. Carney uttered only non criminal speech, opinion, satire, and political hyperbole. There is no criminal intent that can be found from lawful, non threatening speech, and any contrary interpretation of the state picketing with unlawful intent statute violates the First Amendment and the case law comprehensively set forth. Colin Albert. Oh boy. Here we go. Colin Albert is the nephew of Brian Albert, the homeowner of 34 Fairview Road in Canton, where the body of John O'Keefe was found. Reed's defense was posited that Colin may have been complicit in O'Keefe's death. Colin Albert was present at the Albert home, but claims that he left shortly before Mr. O'Keefe and Ms. Reed arrived. Let's take a look at this very long, footnote. So, state police and the Norfolk DA have recently sought to prosecute other defendants for felony witness intimidation for leaving small rubber ducks, saying Colin was in the house around Canton. The same message advocated by Mr. Carney to raise awareness and protest the corruption endemic to the Reed prosecution. All of the cases have resulted in the clerk magistrate declining to issue complaints, and one has resulted in a written decision by Judge Walsh dismissing harassment and witness intimidation charges on First Amendment grounds. The Walsh decision is offered as a defense exhibit filed separately in further support of the McCarthy dismissal request, wherein Judge Walsh writes, "It is the view of this court that the defendant's conduct and speech, though a rather sophomoric expression of his opinion, is nonetheless protected speech." Witness intimidation and criminal harassment charges were thus rejected by the Stoughton District Court. This court should do the same. Excuse me, I have an itch at the tip of my nose. All right. Moving back up here. So Mr. Carney has written and reported extensively on Colin Albert and advocates in his reporting that he was present in the home during the assault and cannot prove otherwise. There's also an exhibit here. Let's take a look at this footnote. Mr. Carney's references to the Advantage Boys and Bang Bang statements on the Colin Albert voicemail and YouTube show are impressions of those statements made by Colin Albert from an intimidating online video made by Colin Albert where he physically threatens rival teenagers called the Advantage Boys. Mr. Carney satirized the statements on the message back to Colin Albert, so he basically repeated it back. As such, it is misleading and distorts the grand jury evidence for the Commonwealth to omit the original statement by Colin Albert, and risks creating the impression that Mr. Carney making these statements constitutes his own threats or fighting words. The original Colin Albert online video is offered as a defense exhibit filed separately in further support of the Odell dismissal request. In the grand jury, Colin Albert testifies to alleged emotional harm, quitting the Bridgewater State football team in the circumstances because he does not wish to be a distraction, and alleges that Mr. Carney calls him a meathead, jock, and bully. I think those are all very apt words to define him. Albert is asked by the prosecutor, why do you think he is doing this? Why do you think Mr. Carney is doing this? And Colin Albert responds that he doesn't know, indicating he doesn't think that it is to intimidate him as a witness. So it's just whatever, one big lie. If you recall his testimony, pretty much all of his answers, I don't know. I don't recall. I don't remember. So the fact that he doesn't know doesn't surprise me. All of Mr. Carney's videos offered at grand jury within Commonwealth Exhibit 1, as well as the interactions and public commentary, are protected speech under the First Amendment and cannot support the one charge brought for witness intimidation in violation of MGL 268, Section 13B. As stated, respecting the other alleged victims herein, causing emotional harm to the psyche of Mr. Albert is not criminally actionable. So just because you cause some emotional harm to somebody doesn't mean that they can go and file intimidation charges on you. That's not how it works. If the alleged means is non-criminal speech. So if especially when words are protected speech, you cannot just try to go and file intimidation charges. Yet again, the indictment fails due to the absence of true threats and fighting words, the public concern and newsworthiness of Albert's alleged involvement, and the context and distance provided by cyberspace all contribute to negate probable cause for any crime. The speech, while perhaps juvenile or offensive, or the like, is non criminal and protected as opinion, satire, and political hyperbole. Moving on to Brian Albert. Brian Albert is the homeowner of 34 Fairview in Canton, Mass, or was. He is no longer. But he was at the time where John O'Keefe was found deceased on the lawn. The Reed defense team contends that Mr. Albert was complicit in the assault on Mr. O'Keefe and the subsequent cover up. They further contend the investigation was severely compromised due to his status as a retired police officer. The defense also notes a litany of suspicious behavior on the part of Brian Albert, such as tearing up the floor of the basement, getting rid of the family dog. The defense expert finds to have getting rid of the dog that the defense finds bit Mr. O'Keefe, selling the home, and not leaving the house to investigate the dead body on the lawn when so advised, and alleged inconsistent or incredible statements. Brian Albert is the alleged victim of one charge of picketing with unlawful intent. Albert made several generalized characterizations of behavior from the rolling rally, claiming that Mr. Carney was attempting to intimidate me and saying things of a harassing nature, and he's going to get everybody. What does that even mean? Albert felt intimidated and noted that Mr. Carney also addressed him in blogs. However, as echoed in all of the other sections, the actual words spoken were not true threats as required or harassment as defined in O'Brien. Albert testified that at the rally he was exhorted to tell the truth and was told that he is lying. Mr. Carney never told Albert to tell the truth, but rather addressed the audience and brought awareness to Albert's involvement in the John O'Keefe homicide. I remember that. He never addressed Brian like him. He never addressed Brian in his speech. I remember him talking about what Brian did and how he was involved so that all the neighbors and everyone around would know. And that's not a crime. None of the recorded statements involving Brian Albert at the rally can be divorced of their First Amendment protection and reasonably be construed as threats or fighting words. Where such protected, pure, non criminal speech is the only reported basis, the First Amendment bars the state from criminalizing such speech, regardless of the hurt feelings of the alleged witness or his family. Protected words of protest uttered in public involving a matter of public concern are entitled to the most heightened First Amendment protection and cannot be made criminal, i.e., an expression of criminal intent to impede, obstruct, delay, or influence by a subservient state statute. Stated another way, if lawful, protected speech impedes, obstructs, delays, or influences a proceeding or a witness that is a lawful manifestation of a free society, a product of the marketplace of ideas, and cannot be made criminal. So you're allowed to be able to go against the man, go against the grain if lawful. You can do so. And it can't be made criminal. So Juliana Nagel is our next one, and they call her Bagel Julie Bagel or Bagel Bites. I don't know why. I just think it's funny. So Ms. Nagel was present at 34 Fairview Road the night of Mr. O'Keefe's death. She initially admitted to seeing a dark figure on the Albert lawn. Her involvement in the case was addressed at the July rolling rally in her neighborhood. Like Brian Albert, Ms. Nagel parroted all the conclusory key words in the statute. She claimed that Mr. Carney harassed me at my residence, he was intimidating, I was harassed. Yet, when the underlying words and statements and video are analyzed, there are no threats or fighting words, only expression that there is a cover up and that Ms. Nagel should come out and tell the truth. The prosecutor again elicits opinion testimony. Question: so, in your opinion, is he insinuating that you lied about this? Answer: yes. He does think that, yes. Question: in your opinion, is he trying to get you to change your testimony? Yes, correct. Only in the prosecutor's Kafkaesque worldview can telling a witness to tell the truth be a felony. In reality, where there are no threats or fighting words, protected speech cannot be characterized as a crime, is not evidence of unlawful intent, and absent such evidence, the picketing with unlawful intent indictment cannot stand. Chris Albert. Christopher Albert, in this section hereinafter Albert, is a Canton town selectman, the father of Colin Albert, and the brother of Brian Albert. Albert was out drinking at Canton bars with the group that later left and went to Brian Albert's home on the evening of O'Keefe's death at 34 Fairview Road. Albert did not go to his brother's home that evening, so he testified, but there is a police report which says otherwise, that they did go. Him and Julie went to Brian Albert's home that night, but they changed their story apparently. Or it's another police report that's just wrong. I don't know. Mr. Carney has been reporting on Albert, urging him to come clean with the full story of his family's involvement in the death of John O'Keefe. Mr. Carney reports and believes Albert is complicit in the cover up. Mr. Carney notes to his listeners that Colin Albert appears to have received special treatment from investigators and that he has a long-standing family relationship with Trooper Proctor and/or Proctor's family, which would constitute an obvious conflict of interest. Of further public concern is the status of Albert as a Canton selectman and the brother of a Canton police officer, Kevin Albert. Chris Albert also owns a pizza shop in downtown Canton. Mr. Carney has protested and raised awareness in downtown Canton and then reports on his findings on his live show and other online outlets. Mr. Carney is charged with one count of witness intimidation involving Chris Albert. Chris testified that Mr. Carney called him and his wife in an effort to ask them questions about the Reed case and went to his pizza shop to speak with them. Albert trying mightily to touch on all the key words such as harassment, intimidation, economic hardship, alleged actions of others, minions, he used the word minions, as referenced by the prosecutor, and the like, Albert was still unable to provide any evidence of true threats or fighting words employed by Mr. Carney. Instead, the testimony and video show Mr. Carney again practiced his protected mix of dogged investigative journalism, advocacy pointed political hyperbole, satire, and opinion. Albert's exaggerated claims that Mr. Carney followed him, confronted him, called his phone, showed up at public meetings, are all normal protected things that journalists do to try to extract answers from people, from different persons of interest and public concern, who they believe are hiding something or advantaging themselves through their privileged positions. None of the episodes related by Albert resulted in police action or arrest, even ignoring the fact that non criminal speech is protected even if it causes economic and emotional harm. Albert's testimony is speculative and insufficient. It is also blatantly misleading in parts. He is specifically asked by a grand juror after his testimony on the summer 2023 activity, did they advise you to file any kind of a harassment order or anything like that? Albert replied, no, not at that particular time, no. Albert, in fact, did apply for a harassment order against Mr. Carney, so he lied. But did they advise you? So maybe because they didn't advise him, he just went and did it. So maybe he didn't lie, but still he should have made that known at the time that he did get it or try to get a protective order. So Albert did, in fact, apply for a protective order against Mr. Carney on September 28th, 2023, in the Stoughton court, and like Jennifer McCabe, was rejected on First Amendment grounds. Papers from Albert's unsuccessful harassment order attempt filed under separate cover. So these are all the things that they're referencing in here are going to be filed within this filing for the judge to review, but we don't get all the exhibits. We just get the motion. All right, we got just a couple more pages. We are almost done. So, if the grand jury received a truthful answer that the conduct aired out before the body was previously found by a judge to be protected conduct, so if the jury knew that this has already been adjudicated and a judge decided that it was protected, it is likely that no indictments would have been issued for all of the categorically similar conduct presented as to all of the alleged victims. Albert's misrepresentation went entirely ignored and uncorrected by the prosecutor. The indictments should be dismissed for this misrepresentation and the following government in action on their own. So for the misrepresentation and for the government failing to correct it, this should be dismissed. Adding Jennifer McCabe's unsuccessful, undisclosed attempt for an order from Stoughton that was also denied on First Amendment grounds removes all doubt as to that course of action. McCabe's unsuccessful harassment order attempt papers are also filed under separate cover, whatever that means. Albert also complained of economic harm and, armed only with pure speculation, tried to pin it on Mr. Carney. There is no evidence Mr. Carney told anyone to bother Albert or to do anything to affect his business. The only evidence involves Mr. Carney advising someone to not eat or boycott Albert's Pizza due to Carney's view of the lack of cooperation and truth telling in the Reed case, which is protected speech. Carney, see the video of Mr. Carney in downtown Canton at the pizza shop. This activity and the supposed attendant economic harm, blah, 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 I bungled that. This activity and the supposed attendant Economic harm inflicted is a constitutionally protected boycott as set forth in NAACP versus Claiborne Hardware, which established conclusively the right to boycott for First Amendment purposes. Ruling 8-0 that states cannot prohibit peaceful advocacy of a politically motivated boycott. Ironically, the only actual evidence of economic harm to the pizza business comes from Albert's testimony on his own actions turning away anyone who appears to be a Reed supporter and refusing to serve them. So he's causing his own economic harm by not serving certain individuals. Albert's self inflicted wound has nothing to do with Mr. Carney's advocacy or journalism. The Commonwealth's economic harm stricter is unconstitutional and the charge must be dismissed. Trooper Yuri Buchanan. Trooper Buchanan is a supervisor on the Karen Reed case state police team. He oversees Trooper Proctor and was himself punished for condoning and covering up Proctor's misconduct in the Reed case, as set forth. He has been on the DA's detective unit for almost 10 years. Buchanan alleges that on September 15th, 2023, he was a victim of witness intimidation by Mr. Carney. Wah, wah, wah. Buchanan complains that on the public street outside the Norfolk Superior Court, Mr. Carney asked him questions. Oh no. He was asked questions and he was badgered with insults on the way to his police car. He claims Mr. Carney called him a pig and that the state police was ashamed he was wearing their uniform. Buchanan then reports interactions with third parties that upset him, where he and the prosecutor again create the implicit suggestion that Mr. Carney should be held responsible criminally for this discomfort. Here, the familiar refrain in the instant memorandum again applies. Mr. Carney's speech is protected as a non criminal First Amendment expression on matters of public concern. Expressions of disapproval of the police are protected under the First Amendment, and name calling certainly qualifies as such. In fact, the oft cited herein O'Brien versus Borowski case is famous as the case that makes it clear that it is constitutionally protected speech to give the finger to police. So you can flick the police off without any criminal consequence. Just so you know. So long as there are no accompanying actions or other criminal utterances that can create a true threat. So you can stand there and flip them off all day as long as you don't say anything. Don't get it in their way. Don't touch them. Oh, that would be funny to do to all of the certain individuals here who are law enforcement. As in O'Brien, Mr. Carney spoke disapproval to Trooper Buchanan concerning malfeasance in his official duties and also questioned him regarding an unaccounted for Ford Edge vehicle seen outside of the Albert house late at night by the plow driver. The encounter was in public and played out in front of several state troopers doing guard duty on the crowd, as mentioned by Buchanan, and none reacted, intervened, and certainly didn't arrest Mr. Carney for his supposed witness intimidation. So there were other officers all around. Nobody did anything. He wasn't he never was charged for anything. So to now try to say, well, he's intimidating a witness is just bogus. This is because even inexperienced highway state trooper guarding the courthouse know that such an encounter is protected speech, lacks true threats or fighting words, and cannot solely be found to be witness intimidation. The Buchanan indictment, brought in good faith and with anti-constitutional motives, lacks probable cause and must fail. Conclusion: for the foregoing reasons, the indictments lack probable cause and were the product of an irredeemably impaired presentation by the district attorney. All of the charges must be dismissed. So that is what Tim Bradle, whoops, it is so hard to too crooked highlighting. All right, so that is signed by Aiden Carney, Tim Bradle, and Mark Betterow, I guess. So we shall see who argues it. Hopefully, so there is going to be a Karen Reed hearing that day as well. So on Wednesday, um, not sure what time that's going to be, but it probably is going to be completed by the time that this happens. If not, I don't know if we're going to see this being argued on anybody's streams, but we'll see. I think it'll be a very interesting hearing if they are actually allowed to discuss this particular or allowed to argue it, because, like I said, I think there might be some issues where they're going to pull some BS, the Commonwealth, to try to delay arguments on this. So we'll see, because they keep trying to delay everything, as the Commonwealth does. But that is where I leave you guys. So thank you so much for watching. I appreciate you all for being here. Please hit that like button if you haven't already. And make sure you are subscribed as we go over all the doc drops in this case, and some in Aiden's case, the ones that we were able to obtain. And this one was important because it is the motion to dismiss, and I think it's laid out really well. It describes, I mean, there's no alternative. There's no other remedy other than to dismiss these charges. So we'll see if the Commonwealth opposes it. Because at this point in time, as I'm recording this, I don't believe that they have, but I think they might even have until today, to the day that this is airing, to file something. So I'm not exactly sure. But if they don't oppose it, how awesome would that be for Turtleboy? That would be so great. I mean, I don't want to get my hopes up, but it's possible that they don't oppose it because it is such a bad case, and they're too busy trying to deal with what is going on in the Karen Reed case, because it's a crazy circus over there with many, many filings, and Judge Bev just does not know how to control her courtroom and everything. So it's been a whirlwind over there in the Karen Reed world. So maybe they are putting more of their attention into that. I don't know. Maybe they figured Turtle Boy is a lost cause on their end. Like, they're not going to win this. Or maybe they'll just say, hey, send it to the Supreme Court. We don't want to deal with it, or the SJC. So we'll see. We'll see what happens and go from there. And I'll let you guys know. So don't forget, like I said, hit that like button. And I will see you guys in the next one. Take care. Bye now.